Should I represent Sarah Boone? For those of you that don't know, she's accused of murdering her paramour with whom she lived by stuffing him in a briefcase, or I don't know, helping him get stuffed in a briefcase and letting him die of compressive asphyxiation while he's basically begging for his life. She was plastered. She was really drunk. It sounds in her voice. Her voice was slurring, and she heard very well that he was begging for help. She told police officers when she called after discovering him dead in the suitcase the next morning that she indeed had been drinking. Now, obviously, detectives had a few questions and asked for her phone, which she let them search. Big mistake, but they'd have probably got a warrant anyway. That's when they found the video of her taunting the victim while he begged for his life. Sarah, Sarah, Sarah. And she was charged with second-degree murder, which carries in Florida a max penalty of life in prison. So a couple of issues as a matter of review to understand why she is in such deep stuff. Firstly, it isn't a defense to a crime that this victim consented. You know, I mean, he obviously consented to get stuffed in the suitcase. I wasn't there, but you just can't get stuffed in the suitcase and not know it, you know, unless you're already knocked out, which he wasn't. He was awake. So obviously he must have let her zip him up. She's doing some weird stuff, or maybe they're doing some kinky stuff. I don't know. Or maybe, you know, he was just intoxicated as well and they were playing a game, or at least he thought they were playing a game. But let's suppose that he consented to that initial getting zipped up in a suitcase. Then that's no defense for her. You know, you cannot consent to deadly conduct. So say, for example, you and I, whoever's listening to this, whenever you're listening to this, let's just say that we have some beef, you know, we have some drama in between us, and we decide to settle it over a duel. You know, we decide we're going to do it old school, Aaron Burr style, you know, American Revolutionary style. We're going to duel to the end. And, you know, one of us will say wins. Doesn't matter if it is consensual. Same thing with this, you know, who cares if he consented to get in the suitcase and she actually fell asleep, and she'd still be in big trouble no matter what, even if it were charged as manslaughter had they not found a video of him begging for his life and her callously denying him exit from the briefcase, or the suitcase rather. Secondly, perhaps there's an argument that comes to your mind, such as, who really knew that you could die from being in a suitcase too long? I mean, fair enough. I would have never, ever, ever thought about that. Like, you just don't think about that. You know, a suitcase is fabric, you know. I never would have thought that I would have never thought that a suitcase could be even somewhat airtight. I mean, if you thought about it, of course. But who thinks about it? However, the fact is that he was begging, you know. He is on camera begging her to let him out. And I won't play it just because it is a bit morbid, quite frankly, and it's on the internet and it is on YouTube, but I won't play it in my video right now. It's been shown enough. Lastly, you might say, well, maybe she didn't understand his pleas because she was intoxicated, but as a last legal note, voluntary intoxication is never defense to a crime. So the best defense that her lawyers had was a battered spouse syndrome. And you see, typically in self-defense cases, a jury's supposed to look at what a reasonable person in that situation would have perceived. And that is a little different in the situation of the battered spouse exception, or rather the battered spouse defense, because that's not a reasonable person, and it's available in various jurisdictions. And it is definitely available in Florida because we can see there's like 6 matricide trials that are going on or have been scheduled for or have already passed in Florida. So definitely that battered spouse exception is available. And there's definitely a history of violence in between her and the victim, both from him to her and from her to him. So it existed in the past. Still, it would have been a tough sell to get a not guilty, seeing as she just basically let him rot in that suitcase. I mean, a lot of other things that she could have done, short of letting him die in a suitcase of asphyxiation. That said, it was the best defense she had. My understanding is one of her earlier lawyers, and she's had quite a few. I want to say 8 off the top of my head. She had so many lawyers. One of them was proposing that defense. She was not satisfied with that. She wasn't satisfied with anything any lawyer was talking about. Every lawyer knew this would probably be her only defense. So most likely, what those lawyers wanted to do is spend the majority of their time crafting arguments to ask for leniency in the penalty phase, or to get a good plea agreement with the district attorney out there in Orlando, so out there in Orange County. So she wasn't satisfied with that. And while we're not privy to those conversations between her and her attorneys, the many attorneys that she's had, we know from her posture in court and her statements to the court that she just wanted someone to believe in her. She wanted someone to be nice to her. She didn't want someone to say, you know, Sarah, we need to have a plea agreement with the prosecutor. We need to come to an accord with the prosecutor because this is how this looks. She wanted them to show the world who she really was on the inside. Yeah, that's what she wanted. She just wanted to be free, obviously, but wasn't that important, the freedom aspect. It seems more the image aspect, because she hasn't been free for quite some time. It's been around 4 years, give or take a few months. And that's what brings us to where we're at today. Sarah wants a new lawyer. You know, the judge in the case, he said, you know, Ms. Boone, because you just can't get along with any lawyer, I'm going to give you a lawyer. You. It's the best, worst lawyer that you could possibly have. And what did she do? She put out an ad. I want to say, I guess maybe she didn't put out the ad. What did she do? She created an advertisement soliciting a new attorney and asked the judge in her case, in a letter, if he could put it in the break room. You know, the judge's break room. This is a good place to get a lawyer. Why not? You know, definitely wouldn't be one of the 8 attorneys that you already had. Definitely wouldn't want to reach out to family members and say, hey, do you have a lawyer? And you could possibly help me out by hiring him and I'll pay you back one day. You know, you'd probably need some goodwill to get an attorney in a traditional fashion. No, you want that advertisement in the judge's break room to get that justice warrior, that paragon of defense, that hero for the oppressed and the wronged. You want to get that person by putting an advertisement in the judge's break room. So when I saw this, I had to react. Even though it's a bit stale at this point, I think it's been over a week at this point that the said advertisement has been published, but I wanted to go over it because it's something very important that I need you to talk me out of. And that is, I think I'm the guy. You know, I've been trying to talk myself out of it, but I think I'm that guy. I fit all the qualifications. So let's go over those qualifications briefly, because it's been spoken about at length by other people on the internet. So this ad says, inmate seeks attorney, looking for a prosperous challenge. I'm always looking for a prosperous challenge. Who isn't? Ready for your close-up on national television. I'm not, but I can go get a haircut and get ready. Are you zealous with a side of keen? If there were 2 words that would describe my style in court, it would be zealous and keen. You know, equal parts. I want to say a side of keen. I'd say probably equal zealousness with a lot of keen. Probably about, 60% zealousness, 40% keen. So I don't think keen is really a side. It's more like a co-main, Show the world who you are with your original creativity, extraordinary expertise, and confident ingenuity. I mean, she's bigging me up. This totally describes every attorney, but especially me. I would love to be considered creative and an expert and confident. Qualifications must include being trustworthy, honest, passion-driven, open-minded. I don't know about open-minded, but as for the first 3, I think that it really describes me. I've had clients, this is the best compliment a lawyer can get. Maybe not the best, but it's up there. When a former client contacts you out of nowhere, could be 10 years later, and says, hey, I have a lawyer, but I miss you. It's like, I'm back in trouble and I want you to take my case. And it's just awesome, And one of the things I've been told is that I'm passionate about these cases. But I think everyone, when they first start out, is exceptional problem-solving skills. I don't know about that, but I'm always working on them. This is something that you cannot get enough of. Problem-solving skills when it comes to being an attorney, because, that's what you're doing, right? fixing people's problems. Client inclusion at all times. Another big compliment I've got is my communication. If I just leave a message, people really appreciate that. And when attorneys get discipline from the state bar, it's usually for two things. One will get you disbarred, one will get you a reprimand, whether public or private. The one that will get you disbarred is mishandling client funds. That will get you disbarred almost every single time. One that will typically get you a reprimand is lack of communication with your client. This individual pays you and then you don't return messages, or typically just don't return messages. You don't pick up the phone and you don't return messages. Eventually that will get you a reprimand if you show up to court after a client pays you and they haven't spoken to you since they hired you. You have to understand it's a stressful occupation, and sometimes that can happen, particularly when cases pile up, but you can't let it happen in the extreme. The least you can do is just leave a message or have your secretary send them a message, but these things happen. That will definitely get you a reprimand. I've always been complimented for that. I understand people pay a lot of money, man, and I come from humble circumstances myself, so I understand what that is, and I guess I'm not old enough to be jaded, but I'm getting there. Team orientation, I don't know about that. Collaboration, I don't know about that. Now, as a true team, certainly, but the client isn't a team member. If someone's building your home, let's not say building your home. Let's say that your pipe is busted and you have raw sewage going into your backyard. Do you hire the plumber as a team member or to fix the problem? So, I don't know about team orientation with regard to the client, but maybe. It depends. It depends. Extreme efficiency in listening. Oh, well, yes and no. I don't know what that means, but I can be efficient in listening as far as asking questions. Extreme efficiency in listening, communicating, understanding. But you can't be efficient listening to Sarah Boone because she's going to drone on and on. So I guess, I could be efficient. Like, I could probably pay attention to something else, read a book or something while she talks. Dedication to success, possessing a winning mindset. That's every lawyer, man. But, if I could get picked because someone says that I possess a winning mindset, I'm all over it. Capability of excellence in representation, committed. Once again, this is a great compliment that you could get as an attorney when someone says that, you're excellent attorney and excellent defense and you're a committed lawyer. And I've been a public defender, and you don't get bonuses. You don't get to charge more the next year. So when you get those kind of compliments, man, it means a lot. So if she says, hey, this is the guy that is an excellent representation of what it means to be defense, and he's a committed defender, man, I'm all over it. I really think that I'm that guy. Talk me out of it. Maintaining faith in the client and care with the ability to think differently, overcome all circumstances. I know it sounds sarcastic, but you have to be an optimist when you represent people, particularly people accused of serious crimes. And you have to believe that. I know it's crazy. The ability to think differently, believing that you can overcome all circumstances, is the ability to think differently. This woman, basically, the narrative going into this, even though it's not the complete narrative, the narrative will always be, she stuffed him in a suitcase. The prosecution can put that in their opening argument and closing argument, and it's over. This is just, they could spam that. She stuffed him in a suitcase. She stuffed him in a suitcase. Come on, man. So you have to be a little bit diluted, but also within the bounds of your work and sticking to the fundamentals of practice. But diluted is the wrong word, but the ability to maintain optimism that you're gonna get a good result. Maybe not guilty, but a good result. So if you're all this stuff, and I think I'm that guy. If you're all this stuff, an epic opportunity awaits. Sarah Boone, number 20056, Deuce Trey, Orange County Corrections Department. Invest in the oppressed. Believe. Now, everyone that commented on this were kind of ragging on it, but I'm telling you, I kid you not, I want to represent this woman. When I say I kid you not, I kid you not. But I won't. So, but if I would, I might. The thing is, I'm not licensed in Florida. I'm licensed in Texas. I am not licensed in Florida. But, maybe I could get one of my homeboys, from the Florida bar and to co-sign me and just get admitted for that hearing or for that particular case, a pro hoc vice. I don't know, man. I could make it happen, so I haven't given up on the idea. I'm trying to talk myself out of it. But if I was a lawyer for her, this is what I'd do. I'd focus on the client. Take a client-centric approach. And what does she want? The first thing she wants is a bond. Now, here's the thing. She's had her bond hearing. It was denied. Why? Because she stuffed someone in a suitcase and let them die. That's why. And it's on video. So, it looks like she's probably going to prison anyway. That's what you're thinking if you're a judge. And there is some history of domestic violence anyway. So there's that community safety issue. So I would still try to get her a new bond hearing. You're saying, oh man, that's crazy, man, General. I'm hanging up on you right now. That's just dumb. Well, no, hear me out. We have to discuss it with her to know so that she knows that I'm trying. Just one meeting and say we're going to do that, and I tell her what we need to do. Now, Florida is the same as elsewhere, and these are very general principles with courts, and I think that it's probably similar for Florida. You're not guaranteed a bond hearing every single time you'd want one. You'd need to demonstrate that there's a significant change in the circumstances from your last bond hearing. I doubt that she's had that, but if we could sit down with her and try to hash that out, maybe could get her away from complaining for enough time to get some actual facts that might be useful for something else that's even more important, like say a punishment phase, say for punishment penalty hearings. So we talk about that. I'd say, we need to demonstrate a change in circumstances, and I'd try to get as much facts about her family situation as possible and just let her think that I'm working on that, and I would work on it. Of course, if there's nothing there, there's nothing there, which it probably isn't. I'm sure one of the other attorneys, highly experienced lawyers, that the judge has taken off of her case, I'm 100% sure that they explored this avenue thoroughly. But it's the narrative that you're putting forth to the client that gives you an opportunity to hear those things that aren't other than complaints. So that's what you got to do as a new guy. It is what it is. Secondly, the second thing I'd move the court ex parte and ask for funds to get a psychiatric evaluation. I'd want to know her entire history. I'd want to know about, from the first time her mom dropped her on the head to everything that happened afterwards. Seriously though, I'd want to know about the times her mom dropped her on the head, because I'd want to know if there's some traumatic brain injury. She's off. Now, that's not a defense to a crime. It's certainly not a defense to a crime, but it's a starting point to understanding. And once again, you're thinking about trying to get leniency later on. And our first conversations with these kind of facts that we're getting are going to be with the prosecutor, behind the scenes. They're going to be with the prosecutor. She's already done 4 years locked up, She's already done 4 years. So you want to know as much about her as possible, and she's not the best relater of facts. So this narrative that we're going into is going to be, Sarah, just be yourself and get all this stuff done so we can get you that bond hearing that you want so much. So it's for the bond hearing. So I try to move to get that expert. They already have one expert. They have an investigator. We saw him at the last hearing, and she was perplexed by his presence. And this is an individual that was responsible for digitizing all of the discovery content, so the police reports and the videos and all this kind of stuff, all the things that the state has to hand over according to Florida and constitutional discovery rules. So I definitely asked the court for funds to get psychiatric evaluations. If I could, I'd get an MRI on this woman, have her brain mapped. Whatever information is going to be useful, because there's not a lot to work with regard to the facts of the crime. Thirdly, I'd want to do what every other lawyer in her case was probably doing, which is, and I've said this already in steps 1 and 2, build a case for leniency. Now, if you're watching on TV, and this is the downside of her antics, of having been on TV for so long and making her voice heard, because her voice is annoying at this point. It's hard to have sympathy for her because of that video which has been released. That's something that's going to be very difficult in choosing a jury. Trying to find someone that hasn't seen that video, and maybe not, maybe just because I'm watching a lot of court TV and YouTube and LawTube and listening to people comment on it, legal bloggers and attorneys and such. But I'd want to try to build that case for leniency. And I'm doing this all through steps 1 and 2. Step 1, trying to get her on my side by, saying trying to get her on my side by searching for changes in circumstances that we could possibly use to have a new bond hearing. Step 2, getting psychiatric evaluations, money for that, because hey, I might volunteer to be her lawyer to have that epic opportunity in my time to shine, showing the world my my creative skills and my expert legal analysis. It's an epic opportunity awaits for people like that. But I'm not about to pay for expert stuff. We've been working hard. I'm like you, we've been working hard to build something. That psychiatrist you're gonna need to grease his palms to deal with this individual for too long. But anyway, I'd want to know her behavior since middle school. I'm talking work history, community involvement, relationship with her child, relationship with ex-husband. Could all be bad, but I want to know up front. I want to know every person's first and last name that she ever even shook hands with. I just want to know. Maybe we could get some leniency from the prosecutor ahead of time. Doesn't seem like the case, but we don't know everything about her. We can't give up ahead of time. I know it sounds crazy, but think of the epic opportunity. It's a prosperous challenge. It's not a challenge of poverty. It's a prosperous challenge. So the other thing that I think we're overlooking, and it's just me, perhaps it's just me, maybe I'm crazy. Like I said, I'm crazy enough to be actually considering this. I think I could do it. I think I could do a decent job at it. I think I could get over the hump, the hump of that, let's say that prefrontal cortex that just doesn't seem to be functioning properly of the client. I think I could get over the hump and get to the next phase of actually doing the work at the next level, which her other attorneys already started off, but were met by that brick wall of ignorance of the client. So I'd focus on one thing in particular when I'm crafting this argument for leniency once I get over the prefrontal cortex hump. And that's her cooperation with law enforcement. This was insane. Recall, she willingly went to law enforcement to be interviewed. Not once, but at least twice. Secondly, she gave them her phone to examine willingly. They didn't have to get a warrant. They didn't have to go to the justice of the peace and get a warrant. She gave them her phone willingly to examine. So she spoke with them freely. Not just when she reported the crime, but she went to the police station. Look, if this happened to me, I'd be very recalcitrant to go to the police station. Why? Because I do not trust the situation they'll have me in. I tell them, look, guys, I want to speak to you about this because I'm not a criminal. And you're not supposed to speak to police officers. But if I know what I'm a lawyer. It's different. But I'm not about to do that at the police station. Why? Because they'll keep you there till like 2 a.m. and then come through with like some, some KFC or something like this and some cigarettes if you smoke, and then come through with the detective and pretend to be nice guy while you're exhausted and you'll say anything to get out. Police stations do that, and I'm just not getting caught up in that nonsense. I say, look, come to my house, bring your camera, whatever, come at a decent hour, and we'll deal with this. If not, then, proceed with your arrest. Anyway, she went to the police station more than once and did those interviews. Secondly, she gave them that film. That was her. We might brush it off and say it's because she's ignorant. Yeah, well, fair enough. But she still did it, and there's a lot of ignorant people out there. Thirdly, I'd focus on the fact that, yes, she was intoxicated and had diminished capacity to understand his pleas were serious, and that she wasn't just tired of him being there. Now, that's not a defense at all, but they were both intoxicated. It is what it is. So this isn't like some malicious murder of she planned it out. Apparently, when she says she was drunk, she really was. She really was, and it's not a defense. It's not a defense. But let me ask you a question, jury member. If there's 2 people that did the exact same thing, and one was stone sober and the other one was slurring words, and the person in the suitcase was slurring words, wouldn't you say that there's a difference between the 2 in terms of the graveness of it? The result is equally grave, but the planning and preparation of the person that did it while sober, to me, that individual is even more scary. Sarah's far more annoying. I'm really not good at dealing with people with mental health issues. I never have been, or people that are intoxicated. I have a lot of that in my family, of both. And I'm not well at dealing with it, and I'm not very merciful towards it. But standing back and looking at it, I'll tell you, the one that could do something like this while stone sober, man, I don't really know. I wouldn't want to be living next door to him. I don't know if I would ever want that person to ever get out. And it's true. Same thing for Sarah Boone, but one is still worse. One is still worse. It's not a defense, but one is still worse. I mean, imagine vehicular homicide while someone's intoxicated. It's extremely selfish to drive while you've been drinking. But imagine someone intentionally running into people while sober. I mean, just driving like a maniac. I have to say the sober one is worse, man. I'd bring up the fact that if she wanted, she could have completed the perfect crime. Think about this. When there's murders, then they say, well, then he put him in the suitcase, put him in the trunk, and put him in the dumpster. Think about that. She woke up the next day and the man was dead. She already had him in a suitcase, though. Think about that. She could have committed the perfect crime where they never found the body. She didn't. She called the police. She might have called someone else ahead of time. My understanding was that she did, and that individual told her to call the police, but she really, 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 really wanted him gone. She had him in a suitcase. She could have done it 100%. She could have rented a car, or she could have used whatever vehicle they had. I don't know if they had a vehicle, so maybe she couldn't have committed the perfect crime, but let's assume that she had a vehicle handy. She could have waited, put that thing in the suitcase, drove to the swamp, tied some bricks to it, dropped him off. But she didn't do that. She called law enforcement. So, I mean, true, they didn't charge her with the most serious, crime, the first-degree murder. They didn't, charge her with capital murder. So I think the state took that into account. But still, it's something to think about during the penalty phase. Yes, they took it into account, but it's not over. It's far from over. She could be in prison for life. So, I asked people online to talk me out of it. I didn't get a lot of comments in return, but I got 2 funny comments. This one, you'll be bald in a month. Oh, that made me laugh. Now, here's the thing. The photo I have on my profile, it's almost 10 years old, so there's been quite a bit of thinning up there. So I'm not sure if this is an excuse, but I have a few grains left, so maybe I want to hold on to those. So this person is really holding me down with this comment. I appreciate it. This second comment, this one made me laugh. All they said was stand down. They said stand down. That's hilarious, but I appreciate that for real. But I'm thinking about it. It's a little bit, I'm kind of glad that I'm not licensed in Florida. I've been thinking about it because I have family there. I did used to live in Central Florida. I used to live in South Florida. Not from there, I wasn't raised there, but I've lived there a few years. And I have family there, so I thought about getting licensed. And oh man, it's a good thing I did not take that 2021 Florida bar, because I might have just jumped in head first, man. Yeah, I'm looking for a prosperous challenge. Isn't everyone?